is a single document that overrides your will every time. And if you have not reviewed it within the past 12 months, your entire estate plan could already be directing your money to someone you never meant to benefit. It does not matter what you paid your attorney. It does not matter how precisely your will was written. It does not matter if you revised your will just weeks ago. If this document says something different from your will, this document prevails. Not occasionally, not only in certain states, every single time. Federal courts have confirmed it. State courts have confirmed it. The United States Supreme Court decided it unanimously. The document overrides the will. But here is what your estate lawyer likely never explained. There is not only one of these documents. There are at least 5 separate versions hidden inside accounts you already have. And the most risky one is buried in an account many seniors have not reviewed in more than 10 years. By the end of this video, you will know exactly where all 5 are located, what authority they carry, and the one mistake that can turn a simple form into a $400,000 catastrophe for your family. This document is known as a Beneficiary Designation. You completed one when you first enrolled in your 401k at work. You completed another when you purchased your life insurance policy. Your bank may have required one. Your brokerage firm likely has one on record. You signed these forms years ago and probably never thought about them again. And that is precisely where the trouble begins. A beneficiary designation is a binding contract between you and the financial institution holding your funds. It instructs that institution on one issue: who receives the money when you die. And upon your death, the institution follows that form, not your will, not your trust, not a handwritten note, not a verbal commitment made at the kitchen table. They follow the form because legally it is a contract, and contracts take priority over wills. And here is why this becomes so dangerous. The financial institution does not investigate circumstances. They do not contact your relatives. They do not review your will. They do not ask whether the person listed is still the individual you would choose today. They see a name, they distribute the funds, and once that transfer happens, reversing it is almost impossible. This is not a technicality. This is federal law. Let me show you how severe this can become. A man named William Kennedy worked for DuPont for more than 20 years. He had an employer retirement account worth over $400,000. When he first joined the plan, he listed his wife as beneficiary. That was reasonable at the time. They were married. She was the clear choice. Years later, they divorced. After the divorce, Kennedy did what responsible people often do. He met with his attorney and rewrote his entire will. He made it absolutely clear that everything should pass to his daughter. He signed it. It was notarized. It was legally valid in every respect. But he never contacted DuPont to update the beneficiary form attached to his retirement plan. He may not have even remembered it existed. It was paperwork he signed decades earlier on his first day of enrollment. When Kennedy passed away, his daughter believed the money belonged to her. The will stated it plainly. There was no confusion. But DuPont sent the entire $400,000 to his former wife because her name remained on the beneficiary form. Kennedy's daughter filed a lawsuit. She had the will. She had her father's clear intent. The case moved through the federal court system and ultimately reached the United States Supreme Court. The court ruled unanimously. The beneficiary designation controlled, and the will did not matter. The daughter received nothing. $400,000 gone because one form was never updated. And this situation is not uncommon. A survey by the American Association of Retired Persons found that nearly 40% of Americans with retirement accounts have not reviewed their beneficiary designations in more than 5 years. 40%. That means millions of seniors right now have outdated forms that no longer match their wishes. Divorces occurred, remarriages occurred, spouses died, grandchildren were born. Life shifted in every possible direction. Yet the form remained frozen in time because no one made a call to change it. So the real question every senior must answer today is not whether your will is current. The real question is whether every beneficiary designation on every account you own aligns with what your will actually states. Because if even one conflict exists, the form prevails and your family loses. Here are the 5 places these documents are likely hiding. Number 1. Your 401k or 403b. If you worked for a company, a school district, a hospital, or a government agency, you have a retirement account with a beneficiary designation on file. The average 401k balance for Americans between ages 60 and 69 is $232,000. That entire amount is governed by the beneficiary form. Your will has no authority over it. Your trust has no authority over it. The form is the only document that counts. Number 2, your IRA. Traditional, Roth, SEP, it makes no difference. Every IRA requires a beneficiary designation. And here's the trap that catches many retirees. If you rolled an old 401k into an IRA at retirement, the beneficiary form did not transfer with the money. The old form stayed with your former employer. When the funds moved into the new IRA, you completed a brand new beneficiary form with the IRA custodian. Perhaps you filled it out carefully. Perhaps you checked a box quickly because it was one of many documents handed to you that day. If you cannot clearly remember who you listed, that is the issue. Number 3, your life insurance policy. The average life insurance payout in the United States is $350,000. That benefit goes directly to whoever is named on the beneficiary form. Life insurance is where this problem becomes most painful because people buy policies when they are young and keep them for decades. A woman in Ohio lost her husband after 32 years of marriage. He carried a $250,000 life insurance policy. She believed it would go to her. They had shared over 3 decades together. But her husband originally purchased the policy during his first marriage and had named his first wife as beneficiary. He never updated it after divorcing. He never updated it after remarrying. For 32 years, that form remained in a drawer with the wrong name. His second wife, the woman who stood beside him for 3 decades, received nothing. The first wife, whom he had not spoken to in years, cashed the check within 60 days. Number 4, your bank accounts. Many banks offer something called payable on death, and many seniors enroll without fully understanding its impact. A payable on death designation transfers your entire account balance directly to the named individual when you die. It bypasses probate entirely. It also bypasses your will entirely. You may have added this feature years ago because a banker suggested it as an easy way to avoid probate. But if the person you named is no longer appropriate or your circumstances have changed, this form is quietly overriding your estate plan right now, and no one realizes it until after you are gone. Number 5, and this is the most dangerous one mentioned earlier, your brokerage account. If you own stocks, bonds, mutual funds, or ETFs at firms like Schwab, Fidelity, or Vanguard, there may be a transfer on death registration attached. Some of these accounts contain $300,000, $500,000, even more than $1 million. This form sends the full account directly to the listed person with no court involvement, no probate, and absolutely no role for your will. Seniors who set these up in their 50s and never reviewed them again are leaving a ticking time bomb for their families. And because brokerage accounts often grow significantly over time, the balance today may be 3 or 4 times larger than when the form was originally signed. Now let me explain the 4 mistakes that cost families the most. The first mistake is naming your estate as beneficiary instead of an individual. This may sound logical, but it is one of the costliest estate planning errors. When you list your estate, the retirement account becomes part of probate. That brings attorney fees, court expenses, and delays of 6 months to more than a year. But the true damage comes from taxes. When a spouse inherits a retirement account directly through a beneficiary designation, they can roll it into their own IRA and continue deferring taxes for decades. When the estate inherits it instead, that rollover option disappears. On a $300,000 IRA, this single error can generate over $75,000 in accelerated federal income taxes that would not have been owed if a person had been named. The second mistake is failing to update after a divorce. In many states, divorce does not automatically remove an ex-spouse from a beneficiary designation. Some states revoke a spouse for certain accounts, but the rules are inconsistent and do not apply to employer retirement plans governed by federal ERISA law. Federal law overrides state law in those situations. If your ex-spouse remains listed, assume they will receive the funds until you confirm otherwise with the institution. The third mistake is naming minor children or grandchildren directly. If a beneficiary is under 18, the institution cannot legally give them the money. A court must appoint a guardian to manage it. That leads to court supervision, annual reporting, legal involvement at each stage, and guardian fees that can consume $20,000 to $30,000 from a $200,000 account before the child receives a cent. The fourth mistake turns everything into a tax crisis. Before 2020, a child inheriting an IRA could stretch distributions over a lifetime. A 45-year-old inheriting $500,000 could take small withdrawals over decades, while the rest continued growing tax-deferred. Congress changed that rule. Now most non-spouse beneficiaries must withdraw the entire inherited IRA within 10 years. Consider the numbers. If you leave a $500,000 traditional IRA to a son earning $120,000 annually, he must distribute the full amount within a decade. If he withdraws $50,000 per year, his taxable income rises from $120,000 to $170,000. That increase can push him from the 24% federal bracket to 32% on those withdrawals. Over 10 years, that 8% difference alone costs $40,000 in additional federal taxes, not including state income tax. So your beneficiary designation determines not only who receives the money, but also how quickly the IRS collects its share. If the form is incorrect or names the wrong person improperly, your family pays the highest tax possible and cannot undo it after your death. And here is something else many people misunderstand. A power of attorney does not solve this. Some seniors believe that if they become incapacitated, their power of attorney can update beneficiary designations. Most financial institutions do not permit that. A power of attorney generally allows someone to manage finances and pay bills while you are alive. It does not grant authority to change who inherits after you die. So the only person who can correct a beneficiary designation is you, and the only time to act is now, while you are capable of making the call. Here is what you should do this week. Step 1. Contact every financial institution where you have an account. Your 401k administrator, your IRA custodian, your life insurance provider, your bank, and your brokerage firm. Ask a single question. Who is currently listed as primary and contingent beneficiary on my account? Do not assume. Do not trust your memory of what you completed years ago. Obtain the exact names currently on file. Some institutions will tell you over the phone. Others will send written confirmation. Either way, get documentation. Step 2. Compare each form to your current will or trust. Place them side by side. If any name differs from your estate plan, remember the institution follows the form, not the will. Update the form immediately. Step 3. If you have a revocable living trust, consult your estate attorney about whether any retirement accounts should list the trust instead of an individual. This is not always appropriate due to tax consequences, but it must be an intentional decision, not an oversight from paperwork signed 15 years ago and forgotten. Step 4. If you have ever been divorced, review every beneficiary form across every account, even those you believe were updated, especially employer retirement plans and life insurance policies. Those two generate the most legal battles and involve the largest sums. Step 5. Never name minor children or grandchildren directly. Instead, Name a custodian under your state's Uniform Transfers to Minors Act, or name your trust with detailed instructions for managing funds until the child reaches the age you choose. One phone call to the institution holding your largest account could protect your family from losing $400,000. So make that call before the end of this week.